interpretation of a doctrine of selectively advanced by Muslim Islam. This court, as a secular institution set up under a constitutional regime, must steer clear from choosing one among many possible interpretations of theological doctrines and must defer to the same course of accepting the faith and the belief of the worshipper. Faith and belief of the worshipper. Here, the faith and the belief of this lady as to how she should dress up, in conjunction with what is stated in the Quran, my Lord. Your Lordship must respect me, Lord. And number 19, my Lord, definitely contradicts what is already stated. And my Lord, totally overrules the particular, your Lordship should not be guided by that particular statement. Then your Lordship will see that the learned Advocate General stated, that what is stated in the Quran, though obligatory, need not be a religious practice, my Lord, is totally contradicted. In Shaira Banu's case, my Lord, Justice Nariman referred to what your Lordship may kindly see at page.
May we suggest one thing?
Yes.
You have banked upon an avalanche of decisions. They have relied upon a train of decisions. You give short note as to why the decisions cited by the state side are not reliable. They will not advance their case. Similarly, Advocate General also, it's a request to you also. Yes. Give a note as to why these decisions do not support each other's case.
No, sir.
That will save time of rest of the people. Otherwise, endless. That's the reason.
Yeah, Lordship. Yeah,
yes.
Lordship will say, my Lord, that your Lordship will kind enough to give us the permission to file our written submissions, my Lord.
Yes, we have, every day we are saying that. Yes. We have from the beginning telling to your written submissions.
Yes, my Lord. So, my Lord, that's, my Lord, only, anything else to send that? Yes, my Lord, only, at Shaira Banu's case, only one line, my Lord, I would like to point out. Page.
Yeah, the common judgments which both the sides have relied, but on their own way.
Yes, sir. No, only one thing. You know, there can't be any dispute or discussion on that. Paragraph 54, my Lord, at page 69 of the reporter, my Lord. Then, my Lord, I will just read 2 or 3 lines. In 54, my Lord, after the degree of obedience, it is stated, one line is all. Indeed, Islam divides all human action into 5 kinds. As it has been stated by Justice Hidayatullah in his introduction to Mullah, there it is stated, E. Degree of obedience. Islam divides all actions into 5 kinds which figure differently in the sight of God and respect of which his commands are different. This plays an important part in the lives of Muslims. First degree, whatever is commanded in the Quran, Hadith or Ijma must be obeyed. That's all.
Thank you. Thank you. Yes, anyone else for the rejoinder?
I'm much obliged to your Lordship for giving me this time, and I'm trying to be as brief as possible, my Lord.
Thank you.
My Lord.
May I please the court?
I am Dr. Kulkarni, my Lord.
I appear for the petitioner in WP 2347. In furtherance of what I have already presented before the court, only on 2 aspects about which the Learned Advocate General has responded to my submissions. The first one is, court may kindly recollect, the Learned Advocate General was fair enough to say that the order of delegating the power to the college working committee, college development committee is not to be derived from any specific provision, but he would say that this can be issued under the removal of difficulties clause, and that is how My learned friend has justified the issuing of the government order.
Sir, we are not convinced of that at all. Therefore, kindly address some other point. We are not convinced of that.
No, if that
Yes.
is so, then I will leave it there. I wanted to cite two authorities to say removal of
Yes.
difficulties. First of all, difficulty is a pre-existing requirement. It is well settled. What is the difficulty? My learned friend has not stated. Number two, it cannot be used to create a new body, contrary to the scheme of the act and the rules.
Yes.
Court may kindly take two judgments. I will not cite it. Kindly permit me to. I'll place it in my written submissions
He
as well.
said that has been done in order to give effect to the Rule 11.
That's all.
I very respectfully submit Rule 11.
No.
Give effect to Rule 11.
Yes. No. All that I am saying is removal of difficulties clause will have no application. Madhava Upendra Sinai versus Union of India, 1975, 3 SCC, page 765. Para 40. It's a constitution bench judgment.
Yes.
Again, Gammon India versus Union of India. Again, a constitution bench. 1974, 1 SCC, page 596. Para 38. So, removal of difficulties clause is not applicable. I'm grateful to the observation of the court that the court is already convinced about the non-application. The other thing is what my learned friend Mr. Sajan Puvaya has so eloquently put it, that a local MLA sharing the power as conferred on the CWC is not contrary to the statute or is not something unacceptable constitutionally.
Yes.
May I request the court to kindly see the composition of the, for a minute, composition of the committee.
In the Rule 11.
No. This is not under any provision of
Or
law.
under the order.
That's circular.
Impugned order.
21/1/2014 circular.
That is not.
Kindly take it for a minute.
Yes, you read, sir. We also remember.
Yeah, president will be the local MLA.
His nominee.
MLA of the constituency. Nominee number 1 is the vice president, who is the local representative of the MLA. 4 nominees to be members. It is not said who is going to appoint him. Definitely, as captain of the team, MLA will appoint. So again, 4 more nominees of the MLA. The person who is interested in educational field, once again, the choice will fall on the MLA because nobody can stand up against the MLA. They are all very subordinate officials. Then two members of the students' representatives. One should be a girl student. Again, the MLA has the power to nominate.
Yes.
Then the vice principal or a senior teacher. Again, their discretion is given. The MLA will nominate somebody of his choice. Then senior lecturer. Again, he may be chosen, not the senior most, senior lecturer of people. Now, out of 12 members, kindly notice, 11 members are nominees of the MLA. Absolute power is given to the MLA to administer the college. The principal will be a member secretary only to implement the decision of the MLA endorsed by this committee. So I therefore very respectfully submit that this is an absolute power given to the MLA. The college is handed over on a platter to an MLA who is a political office holder. And my learned friend Mr. Sajan Puvaya has so eloquently put it that there is nothing wrong in nominating MLA. He is a local man. He knows this thing. I have only one statement to make. The issue of entrusting the elected legislator or a member of the parliament with an executive function or an executive power is no longer resident. Court may kindly recollect, the government of India introduced a scheme to give funds, what are known as MPLA. Member of the parliament were given huge amounts of money. From time to time, it has been revised.
Apex Court said it is bad.
The MLAs were
Apex-
given, sorry,
Apex Court found fault with that.
yes, Beam Singh
When they give the judgment.
Beam Singh versus State of Beam Singh versus Union of India. They ultimately upheld the scheme, not because MPs were endowed with any executive power, but because they had only a recommendatory role. They did not have administrative power. Now, only 3 paragraphs, para 77, 78, and 87. Kindly come to para 77. At page 572. At page 572. Another contention, Madam Justice Kaji has got the judgment. At page 572, Madam. Yeah, para 77. Another contention raised by the petitioners is that the scheme violates the principle of separation of powers under the Constitution. The concept of separation of powers, even though not found in any particular constitutional provision, is inherent in the polity the Constitution has adopted. Kindly mark it. Inherent in the polity the Constitution has adopted. The aim of separation of powers is to achieve the maximum extent of accountability of each branch of the government.
And they refer to Ram Jawai.
Yeah. While understanding this concept, 2 aspects must be borne in mind. 1, that separation of powers is an essential feature of the Constitution. 2, that in modern governance, a strict separation is neither possible nor desirable. Nevertheless, till this principle of accountability is preserved,
Till this principle of accountability is preserved.
Nevertheless, till this principle of accountability is preserved, there is no violation of separation of powers. We arrive at the same conclusion when we assess the position within the constitutional text. The Constitution does not prohibit overlap of functions, but in fact provides for some overlap as a parliamentary democracy. But what it prohibits is such exercise of function of other branch, which results in wresting away of the regime of constitutional accountability. Now it is summed up at para 87. There is an exhaustive review of the cases. I will not trouble the court. Kindly come to one short paragraph at page 575, para 87. So, para 87 at page 575. Thus, the test for the violation of separation of powers must be precisely this. A law would be violative of separation of powers, not if it results in some overlap of functions of different branches of the state, but if it takes over an essential function of the other branch, leading to lapse in the constitutional accountability. It is through this test that we must analyze the present scheme. They endorsed this scheme because MP had only a role to recommend and not to implement or not to exercise any executive power. Now, kindly test on the test laid down by the Honorable Supreme Court. Test the validity of this exercise. There is absolutely no accountability for the MLA who functions as an absolute monarch in the college. No control over him. Can the principal sit in judgment over the action of the committee? Can the DDPI sit in conduct of the MLA? Can the government do so? My very respectful submission is that is a gross anachronism in the scheme of things. That MLA should be made accountable to somebody. Supposing there is misuse of funds in a college, and this committee is responsible for it. Sir, who should hold that committee accountable? Who should recover the money? Who will take the disciplinary action and against whom? That is the crux of the accountability question. With great respect, that is what is hijacked by the MLA through this exercise done by the government. So with these submissions, I rest. Rest of the aspects are covered. I will not trouble the court. I am deeply obliged for a very patient.
Thank you.
My
Thank
lord,
you.
I am the petitioner, Dr. Kulkarni in PIL 3424.
Yes.
Can I submit my rejoinder, my lords?
Yes. Petition number.
Petition number 3424. 3424 of 2022.
Yes.
Page number 30. Can you get it, my lords? Rejoinder, page 30.
3424.
Page 30.
Which one is 3424?
Yes, please.
30 to 35. Within 3 minutes, I will read his lordship's permit.
Yes.
Yes. Paragraph 1 of page 30, that it is undoubtedly and vehemently denied that sporting hijab is not quoted in the Holy Quran. In fact, as per verse 59 of Al-Hijab of the Holy Quran, the following translations are available, my lords. A.
They are read already. Dr. Saab, they are already read in pre-read petitions. They are reproduced. Therefore,
my
kindly say
lord.
something else.
My lord, okay. Para number 2, my lords. Para number 2 on page 31. Justice Dixit Sahab, have you got, my lord?
Yes, yes.
That it is denied that wearing hijab is against public order, morality, or health. In fact, by not wearing hijab, it is respectfully submitted that public disorder is being seen in our state. Disturbance in social fabric is seen in the form of riots, communal disharmony, and recent murder in Shumagga. That wearing hijab is not against public order, morality, or health. In fact, banning of hijab in schools and colleges has affected the mental health of Muslim girls, more so the mental health of girls sporting hijab. Para 3, that it is respectfully submitted that the constitutions of Turkey or of other foreign countries need not be imbibed, need not be inculcated or practiced as being authoritative for the citizens of India. That our Indian constitution is supreme. It is the Holy Bhagavad Gita, the Holy Quran, the Holy Bible, and the Holy Guru Granth Sahib for all Indians. Hence, it is humbly submitted that banning hijab amounts to violation of Articles 14, 19, 20, and 25 of the Constitution. Para 4, that as per the Holy Quran, hijab is being sported as a cultural practice and custom since 1400 years. That customs are an authentic source of law, be it Hindu or Islam. That our Indian Constitution is held in highest respect throughout the world.
No, sir, we will not permit reading that. You have filed it, we will look into it.
My lord.
Yes.
Para number 11, my
So
lord.
every paragraph we will read. Every paragraph written.
One
by us.
sentence,
Yes.
para number 11, that a highly inflammable atom bomb of hatred in the society has grown fully and reached its Himalayan peak.
And that was number 1. But this, no, I'm just bringing about great,
Just
Slightest
little
spark,
fuel.
slightest spark by persons with vested interests may ignite and explode it, causing loss of
All
life.
right, you provide a copy of the joint affidavit to the other side also. You provide a copy, we will go through it and we will
Yes, my lord.
consider it.
My
Thank you.
humble prayer, my lord, that today you can kindly pass an interim relief of allowing hijab on Fridays and Ramzan till the final verdict is delivered, my
Oh,
lord.
no occasion for that. There is no occasion for that. We are in the mid of the final hearing. We have almost at the conclusion
My
stage.
lords, my lords,
Now
my
we
lords.
will
My
pass
lord.
the final order.
I will vote out your verdict, my lords.
Thank you. Yes, next.
Yes, my lord. But there's one application, my lord. Impeding application.
No application, we are not taking. We are not taking any application. Always. Yes.
My lord, this is a PAL, my lord, wherein my lord, all the media houses numbering about 74 are made as respondent.
You have not argued yet?
No, my lord, no.
Including the PL rules not followed. Now,
Lord,
today
two
it has
citation
filed
also I have placed on the
private is filed
current copy on the other
to
side.
comply with the PL rules.
Yes.
Please. Not the entire issue.
Who are you?
My lord, I am the social worker, my lord. I have no personal interest. I have been giving social work, my lord. I am seeing the plight of, my lord, the young children who are chased, photographed, displayed, Lord, humiliated by the media near the vicinity of the college premises and while proceeding to the colleges and schools, my lord. I have filed this PAL, my lord, to restrain the media, my lord, not to shoot, chase us, Lord, while removing the Hijab, that's what's called as burqa, Lord, they shoot photography, displayed 24/7. My respect to submission, my lord, the entire issue revolves around, my lord, wearing of headscarf, otherwise called as hijab, in a pre-university college. My lord, this honorable court was able to pass an interim order, my lord, confines to classroom to those institutions, my lord, there is a committee passed uniform. Now, your lordship may kindly appreciate my respectful submission here. My lord, pre-university colleges or schools, my lord, in the age group of 16, 17 and less than 18, my lord, under various acts, including POCSO Act, Lord, a person less than 18 years of age is called a child, even in JJ Act and other acts. Lord, the child issue is involved. Your lordship may kindly appreciate this honorable court passed an order making it clear in the classroom. Lord, I am not going into the classroom issues. Lord, I can wear a burqa or hijab up to the gate of the college. I can enter into the college with that attire, my lord. My lord, I can move around, go to canteen, library, Lord, playground, anywhere I can move with that. Lordship's order confines into the classroom. But the reality, my lord, in almost all taluks of all the districts, from one end to the other end, my lord, wherever this government-run pre-university colleges, particularly other government schools, my lord, band of media men with cameras. Lord, the visuals I have produced, the screenshots, color shots, Lord, Lordship may kindly appreciate. Lord, a girl is walking, she's aged about, Lord, hardly 14, 15. She is being chased, she runs. Lord, behind that media people, when she removes her hijab, they shoot. Lord, one teacher, my lord, She also goes to the school. But in the gate she was stopped. That's not the order passed by attire. But of their own choice in the public place. But only it applies only to the classroom. Therefore, Your Lordship, I have produced
What is the material? What is the material to say all this? What is the material?
My Lord, I have produced the CD, my Lord, with 65B certificate. My Lord, all those visuals, my Lord.
The visuals does not show that they are being chased. The students are being
Lord,
chased.
there are instances to visual, my Lord.
Or doing anything.
Yes, my Lord. Your Lordship may kindly appreciate in the CD, all that is recorded. I have filed a 65B certificate of. But certain screenshots also I have produced. Not every colleges, not in Tumkur in a particular college wherein the order does not apply, not the policemen go there. At the gate, the principal restrains these girls who are also child. I submit it as a child abuse, not child have right. Not they were made to stand at the gate. And a policeman chases them. The girl says, I am under the depression.
What is your grievance? Your grievance is against media persons or
please, my Lord, my grievance and humble prayer is let the media houses be restrained, my Lord, without let them not intervene with my right of privacy.
You have to first establish what wrong the media persons or media people are doing.
My Lord, they are doing
to show that these media persons are involved in illegal activities or they are harassing these students who wear the hijab, or they are chasing them. There is nothing on record to show that.
I have stated, Lordship, I kindly appreciate the media persons, Lord, my Lord, directly, overtly, or covertly helping some ruling dispensation in order to criminalize, humiliate, demon these students. Only they are segregated, targeted, and they are being criminalized as if they were not a person. The student is going to the college. A teacher is going, chasing me, Lord, shooting me, Lord, 24/7, around the clock, go on displaying. My privacy is involved. The shots indicates that the teacher removes her burqa in compliance of the order passed by this honorable court. She is removing the burqa that is being shot.
Where is that?
My Lord, in the CD I have produced, my Lord. It is there in the CD.
CD we cannot play right now.
The CD I have produced.
There is no other material which shows that in any manner these media houses.
Page number 24 may kindly be perused. Screenshot. Wearing hijab.
You make a complaint to the authorities. They will look into your complaint. If any individual person is agreed by any individual.
School principal lodges a FIR against these children. My Lord, that was registered as an FIR. Principal is the first instrument. And the police constable registers it as an FIR.
There is a child commission.
Please,
there is women's commission.
Please,
there are police. Several 13 legislations protect women and children.
Please, my Lord.
Therefore, make use of them, not in PIL. We cannot undertake monitoring of these things.
Jurisdiction point, my Lord. Jurisdiction, Lord, from every taluk this is going on. One end to the other end. Lord, the state is a mighty state. Police is powerful. Ruling dispensation is very powerful. We are not able to do that. Therefore, the PIL. Otherwise, if they are capable of going to the police station.
At least if you had given such a representation to the commission.
Representation is given.
Where is that? Where have you mentioned?
Lord, many representatives, I have stated that, my Lord.
Where are the representation? You might have stated so many things.
Not a single complaint to the police also.
Where have you given? We cannot, similar matter, the Apex Court in 1996 considered almost similar matter. And court said, we cannot prescribe all these things at all. Thereafter, 1997 Supreme Court, 2014 Supreme Court. It's not that easy. Therefore, we cannot expand all this.
Have been filed.
Take action.
My Lord, they are converting the victim as accused as a victim. That is what is going on, my Lord. Therefore, I am filing this PIL. Lord, it is impossible for the underprivileged.
We
walk up to the police.
Can only observe that whosoever feel aggrieved may make a complaint as per the appropriate legal procedure prescribed and before the appropriate forum.
Please, my Lord.
Yes.
And may I pray for a interim order,
But-
Lord, that they shall not chase us. Lord,
There is nothing on record to.
These hijab are-
We will not entertain your petition. We will dismiss the petition with this observation that whosoever is aggrieved, they make a complaint before the appropriate authority under the appropriate legal procedure, and that would be considered.
There is a committee also. That's what.
We will dismiss this petition, this observation, note down the observation.
Very good petitioner. 2146 Lord. Is the apart from the other very senior advocates also has submitted
Which case here?
2146 Lord. With petition 2146, 1.1.
146. Human forces we have already heard.
Remittal.
Joinder,
Vijay.
wait. Now we have started with the fresh one. Other fresh petitions also there. Call them.
This is already argued by Kamath. Kamath has already argued this matter.
Kamath has,
Not this point, that point. Once reply is given, it cannot be on installment basis.
The actual aspect, because some factual aspects have been, I am not going to stretch anything. I am not going to cover anything.
Mr. Kamath has appeared in this matter
Yes.
or not?
He is not a parent.
He has argued which matter?
He is arguing some other matter.
No, this matter itself. We have
No
not.
issue. Mr. Kamath is arguing the petition which is filed by one Mr. Nayas.
2880.
Mr. Nayas.
My lord, 2880, my lord.
2880 he had argued.
Seeking interlocutory application.
We had argued this matter. He did not.
At first instance, Mr. Hegre has argued.
All right.
That's a factual aspect because very senior 6 advocates has argued on this petition. For that reason, some factual.
All right, wait. First finish with the fresh one, then.
1.7.
Seven of objection, including the PL list of filed.
No one is appearing? Sure. Who is for the petitioner?
He is also
If a petitioner come this side.
Subhash.
Yes, Lord. I'm sorry. Lord, this petition is filed by a practicing advocate. And since this raises an important question which deals with safety, security, integrity, unity of the nation, my lord, every person can be said to be agreed by the what is happening in the state of Karnataka, and which has spiraling impact and effect which has been witnessed all across the country. Now, my submission is this, my lord, that for how many years our courts in the country are going to decide this issue either of hijab or of burqa or of beard. I will take your lordship, my lord, right from 1973, starting with, my lord, state of Uttar Pradesh, the issue of dress code was raised for the first time by a practicing advocate in the city of Bulandshahr in Uttar Pradesh. The matter traveled to Allahabad High Court, and division bench of Allahabad High Court, but for the first time emphatically laid down what is the importance of dress code. And that has unfortunately not been lost sight of by all the courts subsequent thereto, which have not taken into consideration the importance of dress code. For the first time, the importance of dress code was highlighted by Allahabad High Court, my lord, in the compilation of judgment which I have circulated. And if your lordship may be kind enough to have a look at, my lord, I am conscious of the fact that I may have very little time, and I do not wish to, my lord, encroach upon your lordship's invaluable time. But please see, my lord, the compilation of judgment starting, it is 1973, SCC Online, Allahabad 333, and a judgment rendered by Justice M.N. Shukla and Justice K.N. Seth. My lord, an advocate by name Prayag Das, practicing in Bulandshahr. Now he, my lord, filed. He was not permitted to appear by the civil judge there in Bulandshahr. So he filed a petition, and he wanted to. He was perhaps, my lord, espousing for the cause of lawyers appearing in dhoti and kurta, because which was associated with the dress possibly of the India people who were responsible for the freedom struggle. And look at the kind of argument which was advanced. It was stated to the extent that it is derogatory, not permitting dhoti kurta by lawyers in the courtroom is derogatory to national esteem and Indian culture. But even this kind of an argument was not countenanced. The Allahabad High Court, for the first time, and that was possibly the first judgment where the importance of dress code has been highlighted. And what is that, the importance of dress code, my lord, as has been emphatically laid down, my lord, is in Allahabad High Court, is, my lord, your lordship will find, that. Yes, my lord.
Give the citation.
Lord, it is very first judgment from the compilation. It is 1973. It is AIR 1974 Allahabad. AIR 74 Allahabad 133.
Where is the citation?
But that was not school uniform.
No, it was not school, but it was in court. Now, therefore, let us see what is the importance of dress code. Why do we need dress code in the first place?
No, dress code for army, air force, school.
No. All are lawyers, and your lordships, that side of the bench, that side of that side are also in uniform. We are all bound by the dress code. And I'll take your lordship, my lord, to the first, starting from Allahabad, then to Kerala. The matter was taken by another lawyer in Kerala High Court. Now, but first, my lord, is the judgment of
that relevant paragraph you may read, so that
yes,
you can say that.
I'm not taking your lordship, my lord, unnecessarily to. Lord, if the lordship could be kind enough to have a look, running page 6, para 19.
Yes, please.
And there is an argument of Justice Shri V.C. Mishra, rule of unreasonable, arbitrary, and capricious. That was the argument. Running page 6, if your lordship could have a look at, parent 20.
Page number?
Running page 6, my lord. Your lordship will find the pagination on the top. Running page 6, para 20. The sentence starting from, in our opinion.
Yes.
Now, in our opinion, the various rules prescribing the dress of an advocate serve a useful purpose. In the first place, they distinguish an advocate from a litigant or other members of the public who may be jostling with him in a courtroom. They literally reinforce the Shakespearean aphorism that the apparel oft proclaims the man. When a lawyer is in the prescribed dress, his identity can never be mistaken. In the second place, a uniform prescribed dress worn by the members of the bar includes a seriousness. Now, please see, my lord, this could be also made applicable to students. bar includes a seriousness of purpose and a sense of decorum, which are highly conducive to the dispensation of justice. Now here, dispensation of education. Now, para 21, of late, there has been a lamentable slackness in matters of lawyers' dress. We feel that the lifting of the prescribed dress of for advocates and the courts is apt to perceptible sectorial in any elegance and judicial indecorum. If the rule is relaxed, it is unlikely that advocates may start dressing themselves more and more scantily and even indiscreetly. The apprehension that might be illustrated by a dialogue which is alleged to have been transpired between Australian squatter and the friend who visited him is very interesting. Visited him in the estate for far away in the wilds of the interior. The friend asked him why in so remote place he made a practice to dress for dinner. I do it, said the squatter, to avoid the losing of my self-respect. If I did not dress for the dinner, I should end by coming into the dinner in my shirt sleeves. I should end by not troubling to wash. I should sink down to the level of the cattle. I dress for dinner not to make myself pretty, but as a spiritual renovation. Then, my lord, your lordship will turn to, my lord, the Kerala decision on dress, which your lordship will find Dr. Vincent, Lord, judgment starting at, my lord, page 18, running page 18. Now look at the analogy which was drawn. Now the learned advocate in Kerala, practicing advocate, a senior advocate, he took exception to the dress code. He said, why black? Which is reminiscence of, or rather sign of mourning in England. Now your lordship will see that page 18, judgment by Justice Shafiq. And now if your lordship could see the argument advanced, Roman para 2, the exception was taken to climatic conditions and disassociating from the British colonial hangover. And then, now please see para 2. The petitioner is a lawyer by profession. His grievance is with reference to the rules by the advocates, both as a women, men and women in Kerala, are forced to wear black coat, black gown, and with white bands to appear in courts even during summer. He alleges that it causes severe hardship and inconvenience on account of profusely sweating inside the dress and of making it dignified presentation but the next day. According to him, wearing of the said robes, it is difficult during rainy season. According to the petitioner, rules of the dress code thrust upon without taking into consideration the actual requirement. It is pointed out that black dress is the mourning dress in England, which continued to be the uniform of the judges and lawyers, and which is a fact, my lord. It is based on a true story of what happened. Anyway, my lord, I do not want to, my lord. And then, my lord, Kerala High Court, if your lordship could turn to page 20, para 9, relies on the judgment of Allahabad High Court in Prayagdas.
Yes.
And then,
but we have been taught Quinn versus Ledham, 1901, Lord Halsbury's judgment. A case is an authority for the proposition that is laid down in a given fact matrix. How these judgments are going to throw light on the issue. We are speaking of uniform in the school before PUC.
I tell Lord Shimrod, why dress code? Why dress code is to...
You want to emphasize the importance of the uniform.
Yes, my lord, yes. And then, my lord, if your lordship could be kind enough to have a look at page 23, para 18. Coming to the dress code, it is the settled position of law that to practice as an advocate is a statutory as well as fundamental right, and therefore reasonable restrictions can be imposed, providing a dress code for those practicing in various courts can only be termed as reasonable restrictions and cannot be termed as either arbitrary or unreasonable. Now, with this, my lord, I may take your lordship, my lord, to a few judgments where headscarf or hijab was the issue before the High Court. Now, my lord, the first judgment I take your lordship, my lord, to running page 8 by Justice Lodha and Justice Bhosle. Now, my lord, both incidentally were from the High Court of Bombay, where I practice. Now, my lord, if your lordship could see running page 8.
What has been held by this judgment?
Please unmute. Unmute.
Sorry,
Please unmute your mic, sir.
yes, but I'm so sorry. Now, Lord, in this issue, in this petition, in this case also, what had happened? A petition was filed earlier. It was withdrawn. And subsequently, another petition or identical set of facts was filed. The issue is how many courts in India, therefore, Lord, whatever, in whichever states we have high courts, every high court must decide this issue. How many times? It's a criminal waste of judicial time. And yes, my lord. Now, in this case, my lord, it starts that now the issue was that the wearing of headscarf.
Para 7, come to para 7, that has been held.
No, para 6, just 2-3 lines from the center of para 6. The sentence
in a girl's school, a girl wearing not hijab is not necessary.
Correct.
Now, hijab is
only for a minute, if your lordship could also see para 6, my lord, somewhere in the middle, there does not seem to be such established practice and profession of Islam, religion for covering their head by the girls studying in all girls school. Now, please come to para 7. A girl student not wearing the head scarf or head covering studying in exclusive girls section cannot be said to be in any manner acting inconsistent with the aforesaid verse 31 or violating any injunction provided in Holy Quran. It is not an obligatory overt act enjoined by Muslim religion that a girl studying in all section must wear head covering. The essence of Muslim religion of Islam cannot be said to have been interfered with by directing petitioners not to wear the headscarf. Now, my lord, please see, thereafter the matter travels. Incidentally, Fatima.
yes. Why we asked that question?
Now, my lord, the name Fatima is common in both the judgments. Bombay High Court.
Mr. Jasa,
Yes, absolutely.
this judgment, the ratio in this judgment is reiterated by Justice Mushtaq in 2015.
Correct.
Because exclusively girls' school.
Girls is
Where is the point?
girls school.
Yeah.
It's only girls. Yes.
The lordship is referring to the judgment on running page 35, Justice Mushtaq's judgment. That's the Kerala, where also
That's right.
where the issue was. I'll take your lordship to how this issue has been dealt with.
Yes, we have noted that.
Yes, if lordship has gone through. So therefore, at least 2 courts in India have interpreted verse 31. And if we see, my lord, verse number 31 has been read before your lordship, my lord, a team number of time. But if I may be permitted to even without reading, but if I may be permitted, now let us see whether it is possible, it is feasible that what happened 1400 years ago should be applied in 2022 or time to come in future as well. No, the answer to that is no. And I'll take a lordship about how Supreme Court of Malaysia has dealt with this issue. But my lord, nevertheless, now please see, what does it say? There that they should lower their gaze. Now, is it possible for any women? Now, my lord, we are, my lord, and therefore, my lord, this reminds me of a judgment rendered by the Supreme Court. Now, when we talk of these dogmas, We are talking about Bharatvarsh. We are talking about India of 21st. No, therefore, my lord, it is really not possible to follow in the literal sense, literal meaning, each and every
Mr.
word.
Jha,
Yes.
Mr. Jha, this issue we have heard a lot.
No, but
Now,
therefore, I'm not taking a lordship to that. But permit me to take a lordship to two decisions.
You have filed this petition basically with the prayer for a direction to CBI, NIA, or any such other investigating agency.
Yes.
To make a thorough investigation with regard to massive agitation taking place all over the country and spreading over an impact beyond the geological limits of India in the aftermath of issuance of Government Order 5/2022. Now, if there is any material for you to show that it is in a clandestine manner, this agitation has been done or is supported by with some other outside agencies or any organization, then kindly show that.
Yes.
With this prayer, we can consider. But so far as those religious aspects of the matter is concerned, the issues, constitutional issues involved, and all that, we are already have considered that in detail and have heard the arguments of both the sides on those issues.
Before I will take your lordship to the second issue, let me on this issue, my lord, I'll take not more than 10 minutes. And my lord, I take your lordship to two decisions. Now, when we talk of my lord, Mr. Justice Avasthi, my lord asked a question: why to rely on the judgment of other court? Now, but I am taking your lordship to the judgment of a court where Islam is the religion of that particular country, and let us see even in those countries how 31 or similar such provisions have been dealt with, and this is very important. And let us see what Malaysian Supreme Court has to say. Malaysian Supreme Court incidentally relies on more than half a dozen decisions of our Supreme Court.
We have to consider the issues before us, confining specifically to the Constitution.
Yes,
our Constitution, and not to the judgments of other countries and what has been decided there.
Yes. Now, my lord, if your lordship could be kind enough to, where is that here?
Come to your first prayer, please. If you want to press that prayer, then argue that matter.
Where is that here? Yes, my lord. So, Lord, your lordship is, and then please see which are the organizations which have been referred to here.
Yes.
CFI, SIO, Student Islamic Organization, CFI, Campus Front of India, Jamaat-e-Islami, which is funded by Saudi Arabian universities of Islamic to Islamize India and to advance radical Islam in India and submit the report to this honorable court. Therefore, I've said, so all that is required to commence or direct investigation is existence of there being. क्या हो गया यार? अरे बेटा क्लिप लगाया था ना उसको, अभी ऐसा क्लिप लगाया होगा ना, तो 2-3 जजमेंट रखा था उसमें. Yeah. Now, मतलब, therefore, now your lordship may ask me, and the question was quite pertinent as to what is the material to show that now there is involvement of these organizations, and the answer is not very difficult to fathom. Oh, yeah. Now, my lord, what happens is this, that unless and until an agitation of this magnitude cannot be created overnight, and therefore if the agitation is engineered, and this is obviously engineered, funded by some organization, this cannot start out of a blue. My lord, my learned colleagues, my lord, have pointed out to your lordship, lord, that these very girls were wearing, have been seen their photographs. doesn't indicate that they were wearing hijab at any point of time earlier. And then suddenly this kind of an agitation, filing of petitions one after another, engaging senior lawyers from all across the country. Then, my lord, the moment
we cannot go on presumptions.
no, my lord, these are I've stated, my lord, the social media, the information which people have gathered, it is based on materials, my lord. To give to your lordship, my lord, some example of countries like universities in Saudi Arabia funding Indian such organizations, my lord, has come in the light of one Mr. Bashir, who is a journalist, noted journalist in Kerala. And he intercepted some letter on the basis whereof he can infer and construe that this is the game plan. This is the sinister design. So not all that is required is the existence of there being prima facie material to set the criminal law into motion.
Have you tried to collect any material to show that there is some organization, some people who are behind all this agitation?
Yes, my lord.
Do you have any material to show that?
No, please see, my lord, what happened is this. Now, when your lordships were still seized of this petition, bunch of petitions, and started hearing this petition, my lord, about 2 weeks back, one young boy named Harsha was killed. And the CFI, I'm informed, is the organization which has been named in the brutal murder of this young boy, Harsha.
That investigation is pending. We cannot draw presumptions.
No, Lord, with respect.
The investigation is pending. Police is doing its work.
Your lordship,
so unless police comes out with this case that it was this organization which is linked to the killing of that person, we cannot draw presumptions.
May I say this, my lord? May I say this? Now, the requirement, if we see the law, right from 1994, Bhajan Lal's case, to the Constitution bench in the matter of Lalita Kumari, the only requirement in law to set the criminal law into motion is for registration of first information report or for embarking upon any investigating agency to start with an investigation is not even credible information, receipt of an information. Now, therefore, all these attendant circumstances, my lord, sufficiently indicate that there is something much more than what meets the naked eye.
Government is taking the law and order.
Now, please
and wherever there is any problem, they are taking appropriate action. We cannot draw presumptions. This matter requires to be entrusted to CBI or NIA for investigation.
Lord, the request is this, that your lordship may consider, my lord, calling upon the Union of India as a party, Home Ministry as a party. So let there be a report called from the Home Ministry, the Union of India, and tell your lordship's court, my lord, whether there is some sinister design like this.
Prima facie material.
Prima facie
report.
No, but therefore, these materials are in galore. My lord, to give to your lordship, my lord, example, there is one Vinod Anna, who, my lord, hails from the state of Andhra Pradesh, has given sufficient material in his video which he has released. There is one gentleman called Sri Iyer.
Again, muted.
Sinister design. No, at least two. I can tell you also what happens to this. Let us see how these blood outfits. No. So one organization is banned. You start in the name of B. B is banned. You start in the name of C. C, you stop. It starts in the name of D. This is happening all across, not cutting across our Indian territories. It is happening from those people who are in our neighboring country, creating trouble all the time. Pakistan government, for the namesake, bans A organization. They start immediately in the name of B, C, D, E. So therefore, this has to stop. And without filing off such petitions, Lord, at regular intervals, how many hours of judicial work, judicial time your Lordship's court have been kind enough to Lord spend on this issue. So
You
once
consider
this
that.
is stopped, once this is stopped, there will be another petition in another state. So is this that every court in the country must decide this issue every time? The answer to that is emphatic no. So let there be a declaration, Lord, that there shall not be. And Lord, fortunately, for the first time,
We have already called for a report from the government,
yes, Lord.
and we will consider your submissions on
Very
the
well,
proposal which you have made,
very
as
well.
well as that report also.
10
And then
10
we-
more minutes, my Lord. 10 more minutes, my Lord, if I may be permitted to take a Lordship, my Lord.
So please, now we have considered, we have heard you enough.
Only 5 minutes,
We
my
have
Lord.
understood.
Permit me, my Lord, only one small judgment. I will not take a Lordship, my Lord. This is very, very important and decides the controversy. And that is the judgment. That is, my Lord, judgment at serial number 7. It is from Malaysian Supreme Court, Supreme Court of Malaysia. Mayor Atikur Rahman.
What do you want to show from this?
Yes, my Lord, yes. The issue there was
Made us to travel to many countries without visa.
Well said, my lord. My senior colleague has not been even spearheading, my lord. He is attributing to the senior advocates also. Very sad affairs.
no.
Leveling allegation
No,
how
Mr.
we are
Because
engaged.
no,
Please,
Mr.
please
Dar,
go
Mr. Dar,
go to the
don't
ethics,
take me to
please.
tell something
Go to
about
the
you
ethics.
people.
Go to the ethics, please.
Anyway, I don't want. No, don't tell me
No,
about.
you attributed seldom to.
We are almost having the same number of years of practice. Let us not go into that. Now here the issue was
Judgment, Malaysian judgment.
yes, my lord, yes. It is rendered by Justice Abdul Hamid Muhammad, FCJ. Wearing of turban by a Muslim male was the issue.
His number.
Very first page, my lord. Very first page. Held dismissing the appeal per Abdul Hamid Muhammad's FCJ and para 1. The wearing of turban by an adult male, Muslim male, even if sunnat or commendable, certainly does not rank on the same level as sunnat prayers. Thus the practice of a little significance from the point of view of the religion of Islam. Now, I do not want to go into the long history, except to take a lordship to para 14, where if your lordship could see, host of decisions of our High Court, Supreme Court was quoted, the Court of Appeal applying the integral part of the religion. My lord quotes para 14. And then 15, the argument was, look here, why are you citing the judgments of Indian Supreme Court? The answer has been given, my lord, in this next para 15. After your lordship will see Article 11.5 of the Federal Constitution, the Court of Appeal was criticizing for relying on the Indian authorities, especially because the differences between the provisions of Indian Constitution and the Federal Constitution in particular. The preamble of the Indian Constitution declares India to be a secular state and no religion of the state is provided. It is also said who to decide whether a particular practice is an integral part of the religion or not. Now, this issue, without going, my lord, I take a lordship straight away and look at the parallel drawn, which is equally applicable in this case. Please see, my lord, para 34. This is the answer to Mr. Dar and other people. I accept. Your lordship has that, my lord? I accept that prophet wore turban. Your lordship has that? I accept that the prophet wore turban. But he also rode a camel, built his house and mosque with clay walls and roof of leaves of date palm, and brushed his teeth with the twig of plant. Does that make the riding a camel a more pious deed than traveling in an aeroplane? It is preferable to build houses and mosques using the same materials used by the Prophet, PUBH, and the same architecture adopted by him during his time. In Malaysia, Muslim houses and mosques would leak when it rains. There would be no blue mosque or Taj Mahal, not even the present Masjid al-Haram and Masjid al-Nawabi al-Hambara or so and so that Muslims can be proud of. Again, it is more Islamic to brush one's teeth with twig than using a modern toothbrush with toothpaste and water to wash it in privacy of one's bathroom. It is not everything that Prophet did or the way he did that is legally according to Sharia or religiously binding on Muslims or even preferable and should be followed. And then, my Lord, it goes on to.
Mr. Wave, we will consider this judgment.
Please. Very ridiculous. Yeah, that's a sunnah. My Lord, if I am with my Lord's permission, whenever your Lordship
Only
will
1
feel.
minute, Mr. Dar, only 1 minute. Only 1
Please,
minute.
please.
Lord, what happened? Now, my Lord, when we talk of Islam, my Lord, originated from Saudi Arabia. Now, look at what is happening in Saudi Arabia today. The information which is available 2 years back, they allowed, my Lord, women to drive a motor car, which was not allowed in Saudi Arabia earlier. 197,000 women have applied for license for driving motor cars. And look at, my Lord, what the Prince of Saudi Arabia had to say about women empowerment. So therefore, when we talk of, my Lord, women, they are women equally of our country. Nation first. You must follow the law of the land first. And then you are a Christian. I'm deeply obliged to the court for a patient hearing.
There is one review petition. Call the review petition also.
Number 1.8, Rahmatullah Kutwal.
Name of the judgment is?
Shaira Banu.
No, what's the full name?
Shaira Banu versus Union of India. It is the full name.
Who appears in review petition?
R. Kutwal.
Please unmute yourself.
For the petitioner.
Yes.
In this petitioner, my Lord, I bring your kind attention to the order dated 17-2. Page number 5, my Lords, para number 5. I read, my Lord. The petitioner is PIL.
What do you want to show?
My Lord, the findings of the order, I differ with the findings, my Lord. There are incorrect findings pertaining to my writ petition, due to which my writ petition was dismissed. In para number 5, my Lords, I read it as.
Paragraph number 5 of the order.
Yes, my Lord.
Yes.
The petitioner in this PIL seeks to lay a challenge to the government order dated 5/2/2022, whereby the dress code school uniform is sought to be provided for with the formation of college development committees. The very same order has been put in challenge by the aggrieved students in a batch of writ petitions. They are represented by a battery of lawyers and senior advocates. This special bench comprising 3 judges has been hearing those cases since last 5 days, and thus the hearing is halfway through. Thus, it is not that in a worthy cause like this, the aggrieved are not before this court. I pause, my Lord. My Lord, I am in this case, I am connected to this case from the very instant, from the very inception, my Lord. On the very day on which the GO was passed, I had sat the overnight, I drafted this petition. I filed this petition, and my petition was filed even before any counsel was heard. I resume the 5, my Lords. It reads ahead as, nor that the important questions are not raised and debated in the said petitions. Kindly, my Lord, I bring your kind attention to the fact that I filed this petition before any submissions are recorded. In my petition, I have averred my arguments ranging from Article 14, 15, 19,
All right.
21.
We have recorded that this PIL is not maintainable. The aggrieved persons are before the court. They have filed the petitions challenging the government order. They are being heard. So the PIL is not required. The basic concept of PIL is to represent those who cannot approach the court. So the PIL in the given facts and circumstances was not maintainable. This is what has been recorded by the court. So there is nothing wrong in this. There is no error apparent on the face of the record.
My lord, the finding as to that the petition is devoid of merit is very hurtful, my lord. I've included the petition it holds merit. It has every single argument which has been raised.
You are not in appeal, you are in review. You have to show the error apparent on the face of the record. We do not find any error apparent on the face of the record.
Rule 14 has been complied, my lord. I've already complied with Rule 14.
We'll dismiss this review petition.
I take it.
Kindly allow me to file my written submissions. I versus this kind.
Every time you keep on saying, you will not be able to finish the matter.
Before rising, I may be given 3 minutes before rising.
Mr. Dhar, sorry, we will not be
in rebuttal
your
3.
petition was not maintainable, and we heard you just because you insisted.
No, rebuttal, I would like to assist your lordship.
No, sorry.
You have taken more time
You
than
have taken sufficient time. We have heard you at length.
Yes, Mr. I am the main.
Written submissions we can file, madam. Written submission.
Some factual aspects I need to highlight before the honorable.
Give whatever you want to tell in 5 minutes.
Not 5 minutes, I require minimum 10
No, we will not give you enough time. No, we are finishing with the matter today. We will reserve the judgment. Sorry, Mr. We have
factual aspect, it's not been, I have to answer the factual aspect.
You argue. We are sitting here. We're giving you time.
But you kindly take the objection.
We cannot continue endlessly.
I oblige not because some unnecessary petitions are filed. For that reason, so much.
We are saying we are giving you time. We argue it in 5 minutes.
Statement of objection, Lord, filed by the respondent number 5 and 6.
Give the time.
The same document is also relied by the state court.
Which petition you are arguing?
I'm arguing 2146.
Mr. Sanjay Hegde.
Sanjay Hegde is the parent of the first.
Yes.
The document, this petition which is annexed.
Mr. Mohammed Tahir.
Number 20 here. The resolution passed by the CDC on 2018.
Yes.
Where they had declared about the uniform. This is the document which the state also has relied. The same document is also objections of other respondent also has relied. The translated copy on page number 20, Lord.
Yes.
My submission is that, Lordship, this document is fabricated. Fabricated for the purpose of this petition, Lord. Kindly to see the date, Lordship. 2018-19 committee meeting number 1. Date is Date is 23/6/2018.
You say this document is fabricated.
Fabricated. I just from the document itself.
All right. This is election number R2.
R2, Lordship. Translated copy on page number 20. This is the document which is live by the state as well, Lord. And they are stating that this is the resolution passed by the CDC where they had described the uniform, Lord. This is the document.
May I make an intervention with your lordships kindly, my lord? There is a typographical error. That's what he's pointing out, Lord. I am the one who filed this statement of objection.
It's 1%, but it cannot be from everybody. Typography error. You are not filed.
I just.
Yes. What do you want to point out?
The typographical error is this, my lord. If your lordship, my lord, learned friend is drawing attention to the statement of objections. The English version of the typed copy, my lord, is at page number 20.
Yes.
Now, my lord, in para number 2 there, what they are pointing out is this minutes is of the year 23/6/2018. How can there be a reference to date of 21/6/2021? That is the point which they are making. I was also a bit perplexed. Actually, my lord, what has happened is the handwritten minutes in Kannada are available at page 18.
18 of SO.
In the same SO, not page 18 is a handwritten copy of the minutes.
Yes.
My lord, will notice, my lord, this is the number 2 there, and the date there is 21/6/2018. But in the Kannada typing and in the English typing, it is typed as 2021. That's a typographic error, my lord. Your lordship will permit me to correct it. That's all.
Anything else?
No, several things, Lordship. 6 senior counsel has argued against senior counsel. I'll just find out this, Lordship, how it has been created. This is one aspect. One aspect, senior has clarified that. Lordship. They have mentioned 26/2021. Lordship also, and para number 4. Lordship. Further, it is resolved to maintain the same uniform this year also in the last year. That is the blue color so and so. Next page, the blue color shawl on the shoulders.
Blue color
shawl on the shoulders.
Big on.
In the next page, page number 21. If anybody wants to describe uniform, they will not say this where this particular shawl has to be worn with. Because our case was that the shawl has to be give us a permission to use it on the over the head. For that reason, specifically they had mentioned it. Apart from these documents, where CDC is chaired by Mr. the respondent number 15, not even a single document has been produced, which is chaired by the another MLA from 2013 to 2018. Admittedly, between 2013 to 18, another MLA, Mr. Pramod, was representing the same constituency. Not even a single resolution or any single document is produced by that MLA, Lordship, in CDC. And Lordship, kindly appreciate one more very important aspect, Lordship. They have presented documents start from 2014 onwards. Specifically annexed in, kindly turn to page number 7, Lordship, para number 12.
Oh.
The same objects, the same statement of which I was referring to.
Yes.
Para number 12. It is submitted as uniform worn by the student. The college has been prescribed since a very long time, and same has been continued from time to time by passing resolution. Resolution by the college or the committee in this regard, the continuation of uniform was passed 2004, 2006, and 2018. But you kindly appreciate the CDC came into the force year 2014. Before that, there was no CDC. And CDC, the same document option. There is an order of 2014 is provided.
What was the position prior to coming into of CDC?
The CVC was established in the year 2012 itself. I have the file itself.
No, in this paragraph,
yes,
it is said that the resolution of the CDCs are annexed for the year 2004, 2006, 2018. So
there was no CDC.
When CDC was not there, where is the question of resolution of CDC?
It was there.
No, that committee was called the College Betterment Committee. The name is changed, that's all. So College Betterment Committee was what was
Betterment
there.
Committee was rule 11.
That is, must have been somebody must.
College Betterment Committee is what this. But it's the College Betterment Committee, where only this kind of available. 2013, 2018, there another MLA was there.
All right, this committee was earlier known as College
Betterment. There was no such committee is my submission. They wasn't have any power, and the power which was given to them in 2014.
Of what? Translated copy of what?
The way of memo.
What document?
A document of respect of the circular dated 31/2014, which gives the direction about the formation of CDC.
All right, what do you want to show?
I just wanted to say, Lordship, the function which has been assigned Not even a single document has produced which shows that this CDC has done that kind of function. Only the document is related to uniform are produced, fabricated and produced for the purpose of this case. And that was 2018. And the MLA which was presiding before that, no such document.
You say that this was not the work of CDC.
My first
Now, subsequently, they have fabricated these documents to show that CDC has taken over this work of performing the prescribing the uniforms.
Just to purpose this petition.
All.
This is my first submission. But there is also the objection was my learned AG has clearly stated that we are seeking a declaration. And because this is state, they have to take care of the interest of other Muslim women, those specifically not observe the practice of hijab. If the court pass the declaration, it will be adverse to their interest. That was the argument made by the learned. So my submission is, Lordship, already attempts are made to satisfy this honorable court by citing the Quran verses and all. Even just for the sake of argument, we assume that court has declared. Lordship, I just wanted to satisfy this court with another analogy of the namaz, which my learned senior also has compared with. Namaz, nobody has any dispute that namaz is not an integral part of Islam. But still, many people, they don't pray namaz. Does they go out of Islam or anybody declares them a non-Muslim? Even though this court declares that it's a religious practice, it may not be against anybody. Is misplaced. Another argument which was placed here before this honorable court about the secular institutions. Every senior counsel has stressed on the uniformity in secular institutions. But first the question is that which I used to ask to me only. Our secular institution, which so-called institution, they are really secular or not? Because we have adopted the religious practices of all the religions, which are not hindering to anybody else. And judgment which I already have produced with my compilations, and it also has cited. I will not bother this honorable court to read and draw a judgment. It's a judgment of Madras High Court, a double bench judgment, where the question was raised.
That was placed before.
I will just finish my there was question was raised in respect of Saraswati Puja and Ayodhya Puja in government offices. If the question was raised, the court has answered that if any religious activity performed in a secular institution or a place which not hindering to any other individual, then it will be permissible in a secular state like India. But another
yes.
Lordship, I will take another 2 minutes.
Yes, yes.
Now, Lordship, in this particular GU, which is before this honorable court, the question, Lordship, it's a case of indirect discrimination. The state is saying that the order, which is the operative portion, it is not discriminating anyone, and we are giving a power. But specifically, what they have stated, and already Mr. Kabat has explained about it, it's a case of indirect discrimination. Lordship, while passing the interim order on 10/2/2020.
No one has taken this ground of discrimination under Article 14. None of the petitions. This is for the first time you are saying that.
Indirect discriminations are doctrine of indirect discrimination is there from the GO itself.
Online will consider.
Lordship, the uniformity, Lordship. Now, uniformity in a secular place, if it is imposed, who will be at loss? The minority will be always at loss. The uniformity in the name of secularism or in the name of uniformity, any law is made. It is nothing but a brute majority, Lordship. Lordship has passed the interim order, Lordship will remember. While passing the interim order, Lordship has mentioned two things. One is the hijab, other one is the saffron shawl. After that, anybody has complained before this honorable court, we wanted to wear a saffron shawl, this institution, that institution are not allowing us. Who is complaining? Those are observing hijab, either in this institution. The fact is that, Lordship, the practice which was observed by the Muslim girls, it was their religious practice. This was their cultural practice. which out of their conscience they are using it.
All right.
And the separate shawl, which they used by that point of time, it was a hooliganism, Lordship. To counter this, that was a Lordship. Another submission is, Lordship. Our founder fathers of Constitution, Lordship, their intention was not that the part 3 of the Constitution will be applicable only in a private place. So they had given enough right to every individual to exercise their fundamental right in all the places, Lordship. If the Lordship pass an order today, assume for a situation, if Lordship pass an order that school is a secular place, the secular institution, so no religious symbol can be allowed. Or say headscarf is not allowed, for instance, apart from the headscarf. Tomorrow, government will come and government will declare if there is anything with a by notification of this particular road is a secular institution or a secular place. This particular mall is a secular place. So where our rights will remain? Between the four wall of the house. This is not the intention of the framework of the Constitution. Because in Article 25, the word is used freely. Freely to exercise our rights.
All.
Another submission. Last submission. Lordship, the co-warranto has sought in respect of dispensation number 15 and 16. So my submission that aspect, Lordship, when the relief of co-warranto is asked as a person, that time the burden of proof is on the person to establish that under what capacity he is occupied the document. That's my humble submission. Or I have submission which is required, already covered my other friends, Lordship, and already I had made a written rejoinders also, Lordship. That may be considered, Lordship.
Thank you. But judgment reserved.
Closing remarks, I'm not going to make any submissions. But one is, I'm not going to make any submissions. My learned friends who are appearing petitioners have in their own way attributed certain submissions made by the state. In my written note separately will classify as to how we have made. Number one. Number two, none of us will
give it back. You take back this.
Yes. Therefore, we will separately state as
we require, we will ask again.
Very well. We'll keep it. But sir,
close it.
No, it will be sealed. Some attribute, the way they have put it across the way they feel it is convenient to them. But in the separate note, I'll put across how we have made our submission. Secondly, on behalf of the bar, I want to profusely express our gratefulness that Lordships have heard us so patiently in a charged atmosphere. But I wanted to express my profound on behalf of all of us. I'm sure none of us will disagree on this aspect. Thereby, grateful.
I really reciprocate what the learned advocate
heard to kindly give your written submissions, and all those applicants who have moved the application for intervener, if they wish, they may also give their written submission. Whatever
we are
they
extremely
wanted.
grateful, my lord. Grateful for sparing such a great